University of Santo Tomas, Criminal Law Review, Pre-Week Notes of 2016, Part 1.
Distinguish between ex post facto law and bill of attainder. This was asked in the bar 2015. The ex post facto law is any law which makes an innocent act a crime after the act was committed. It is a Latin phrase which means from something done afterwards. It could also be a law which aggravates a crime or makes it greater than when it was committed, or which changes the punishment and inflicts a greater penalty than the law governing the crime when committed. While a bill of attainder is a law which inflicts punishment on a named individual or a group of individuals without judicial trial. The ex post facto law pertains to the act, while a bill of attainder pertains to a named individual or to members of a group. The Congress passed a law reviving the anti-subversion law, making it a criminal offense against for a person to join the Communist Party of the Philippines. Reforma, a former high-ranking member of the Communist Party,
Charge.
under the new law for his membership in the Communist Party when he was a student in the 80s. He now challenges the charge against him. What objections may he raise? This was asked on the 2000 bar exam. The answer: Reforma may raise the limitations imposed by the 1987 Constitution on the power of Congress to enact retroactive penal law, or rather penal laws, which are prejudicial to the accused, under the Bill of Rights of the Constitution. Such is classified as an ex post facto law. It should be noted that when Congress discriminalized the crime of subversion under RA 7636, it obliterated the felony and its effects upon Reforma. Consequently, charging him now under the new law for his previous membership in the Communist Party would be constitutionally impermissible. So, there's another question here. What is an impossible crime? Can there be an impossible crime of adultery? This was asked on 2015 bar exam. The answer: an impossible crime is an act which would be an offense against person or property, where it not for the inherent impossibility of its accomplishment or an account of the employment of inadequate or ineffectual means. This is found in Article 4 of Paragraph 4 of Revised Penal Code. There is no impossible crime. The second question: there is no impossible crime of adultery, since this is a crime against chastity and not against person or property as required in Article 4, Part 2 of the Revised Penal Code. Next question. Carla, 4 years old, was kidnapped by Enrique, the tricycle driver paid by her parents to bring and fetch her to and from school. Enrique wrote a ransom note demanding 500,000 from Carla's parents in exchange for Carla's freedom. Enrique sent the ransom note by mail. However, before the ransom note was received by Carla's parents, Enrique's hideout was discovered by the police. Carla was rescued while Enrique was arrested and incarcerated. Considering that the ransom note was not received by Carla's parents, the investigating prosecutor merely filed a case of impossible crime to commit kidnapping against Enrique. Is the prosecutor correct? If he is not correct, can he instead file a case of grave coercion? This was asked in Bar 2014. The answer: the crime committed by Enrique is kidnapping for ransom. Even before the ransom note was received, the crime of kidnapping with serious illegal detention had already been committed. The act cannot be considered an impossible crime because there was no inherent improbability of its accomplishment or the employment of inadequate or ineffectual means. The delivery of the ransom note after the rescue of the victim did not extinguish the offense, which had already been consummated when Enrique deprived Carla of her liberty. The sending of ransom note would have had the effect only of increasing the penalty to death under the last paragraph of Article 267, and this is also found in the case of People versus Tan, GR number 95322 of March 1, 1993. Furthermore, kidnapping is a crime against liberty. In an impossible crime, it is important that the accused committed an act that would have been a crime against person or property. The prosecutor cannot file a case of grave coercion instead. As discussed above, the crime committed by Enrique is kidnapping for ransom. Okay, next question. This was asked in 2015 bar. Dion and Talia were spouses. Dion always came home drunk since he lost his job a couple of months ago. Talia had gotten used to the verbal abuse from Dion. One night, in addition to the usual verbal abuse, Dion beat up Talia. The next morning, Dion saw the injury that he had inflicted upon Talia and promised her that he would stop drinking and never beat her again. However, Dion did not make good on his promise. Just after 1 week, he started drinking again. Talia once more endured the visual verbal abuse. Afraid that he might beat her up again, Talia stabbed Dion with kitchen knife. Well, he was passed out from imbibing too much alcohol. Talia was charged with the crime of parricide. The question here is, may Talia invoke the defense of battered woman syndrome to free herself from criminal liability? Explain. Here's the answer. No, a single act of battery or physical harm committed by Dion against Talia resulting to physical and psychological or emotional distress on her part is not sufficient to avail of the benefit of the justifying circumstance of battered woman syndrome. The defense of battered woman syndrome can be invoked if the woman with a marital relationship with the victim is subjected to cumulative abuse or battery involving the infliction of physical harm resulting to physical and psychological or emotional distress. Cumulative means resulting from successive addition. In sum, there must be at least 2 battering episodes between the accused and her intimate partner, and such final episode produced in the battered person's mind an actual fear of an imminent harm from her batterer and an honest belief that she needed to use force in order to save her life. This is found in People versus Hinosa, GR number 135981 of January 15, 2004. Here's the second question. Will your answer be the same assuming that Talia killed Dion after being beaten up a second time? Explain. No. The answer, no. Talia can now invoke the defense of battered woman syndrome to free herself from criminal liability for killing her husband, since she suffered physical and emotional distress arising from cumulative abuse or battery. Under Section 26 of RA 9262, victim survivors of battered woman syndrome do not incur any criminal or civil liability despite the absence of the requisites of self-defense. And here's another question of 2014 bar exam. Miss A rather, had been married to Mr. B for 10 years. Since their marriage, Mr. B had been jobless and a drunkard, preferring to stay with his barcadas until the wee hours of the morning. Miss A was the breadwinner and attended to the needs of their three growing children. Many times when Mr. B was drunk, he would beat Miss A and their three children and shout invectives against them. In fact, in one of the beating incidents, Miss A suffered a deep stab wound on her tummy that required a prolonged stay in the hospital. Due to the beatings and verbal abuses committed against her, she consulted a psychologist several times as she was slowly beginning to lose her mind. One night, when Mr. B arrived dead drunk, he suddenly stabbed Miss A several times while shouting invectives against her. Defending herself from the attack, Miss A grappled for the position of a knife and she succeeded. She then stabbed Mr. B several times, which caused his instantaneous death. Medical legal reports showed that the husband suffered 3 stab wounds. Can Miss A validly put up a defense? Explain. Here's the answer. Yes, Miss A can put up a defense of battered woman syndrome. It appears that she is suffering from physical and psychological or emotional distress resulting from cumulative abuse by her husband. Under Section 26 of RA 9262, victim survivors who are found by courts to be suffering from battered woman syndrome do not incur any criminal and civil liability, notwithstanding the absence of any of the elements for justifying circumstances of self-defense under the RPC. Okay, so that's the answer. So, according to Section 26 of RA 9262, I repeat, victim survivors who are found by courts to be suffering from battered woman syndrome do not incur any criminal and civil liability, notwithstanding the absence of any of the elements for justifying circumstances of self-defense under the revised penal code. Here's another question. This is taken from the 2015 bar exam. Dancio, a member of a drug syndicate, was a detention prisoner in the provincial jail of X province. Brusco, another member of the syndicate, regularly visited Dancio. Idre, the guard in charge who had been receiving gifts from Brusco every time he visited Dancio, became friend with him and became relaxed in the inspection of his belongings during his jail visits. In one of Brusco's visits, he was able to smuggle in a pistol, which Dancio used to disarm the guards and destroy the padlock of the main gate of the jail, enabling Dancio to escape. What crime or what crimes did Dancio, Brusco, and Idri committed? Explain. In the case of Dancio committed the crime of direct assault under Article 148 for disarming the guards with the use of pistol while they are engaged in the performance of their duties. Using a pistol to disarm the guards manifests criminal intention to defy the law and its representative at all hazard. Note, illegal possession of firearms may also be considered. Well, in case of Idri committed infidelity in the custody of prisoner or evasion through negligence under Article 224 as a guard in charge. Idri was negligent in relaxing the inspection of the Brusco's belongings during jail visits, which allowing him to smuggle a pistol to Dancio, which he subsequently used to escape. By accepting gifts from Busco, who was part of the syndicate to which Dancho belonged, he is also guilty of indirect bribery under Article 211. In the case of Brusco committed delivery of prisoner from jail under Article 156, which is qualified by his bribery of idri. Helping a person confined in jail to escape constitutes his crime. Helping means furnishing the prisoner with the material means or tools which greatly facilitate his escape. Hence, providing a pistol which helped then shoot to escape is delivery of prisoner to jail. And here's another question from Bar 2014. To secure a release of his brother Willie, a detention prisoner, and his cousin Vincent, who is serving sentence for homicide, Chito asks the RTC branch clerk of court to issue an order which would allow the two prisoners to be brought out of the jail. At first, the clerk refused. But when Chito gave her 50,000 pesos, she consented. She then prepared an order requiring the appearance in court of Willie and Vincent, ostensibly as witnesses in a pending case. She forged the judge's signature and delivered the order to the jail warden, who in turn allowed Willie and Vincent to go out of jail in the company of an armed escort named Edwin. Chito also gave Edwin 50,000 to leave the two inmates unguarded for 3 minutes and provide them with an opportunity to escape. Thus, Willie and Vincent were able to escape. What crime or what crimes, if any, had been committed by Chito, Willie, Vincent, and the branch clerk of court, Edwin and the jail warden? Explain your answer. Okay, the crimes committed in this case are as follows. Chito committed the crimes of delivery of prisoners from jail, which is found in Article 156 of the Revised Penal Code, for working out the escape of prisoners Willie and Vincent. And also 2 counts of corruption of public officials, which is also found in 212 of Revised Penal Code, and also falsification of public documents as a principal by inducement, Article 172, Paragraph 1 of Revised Penal Code. While Willie committed the crime of delivery of prisoners from jail, which is found in Article 156 of Revised Penal Code, as a principal by indispensable cooperation if he was aware of the criminal plan of Chito to have them escape from prison, and he did escape pursuant to such criminal plan. Otherwise, he would not be liable for said crime if he escaped pursuant to human instinct only. While Vincent, being a prisoner serving sentence by final judgment, committed the crime of evasion of service of sentence, which is found in Article 157 of Revised Penal Code, for escaping during the term of his imprisonment. For the branch clerk of court, committed the crimes of, number 1, direct bribery, which is found in Article 210 of Revised Penal Code, for accepting the 50,000 pesos in consideration of the order she issued to enable the prisoners to get out of the jail. Number 2, falsification of public document, for forging the judge's signature on said order, which is found in Article 171 of Revised Penal Code. Number 3, delivery of prisoners from jail, which is found in Article 156 of Revised Penal Code, as a co-principal of Chito by indispensable cooperation for making the false order and forging the judge's signature thereon to enable the prisoners to get out of jail. And last, evasion of service of sentence, which is found in Article 157 of Revised Penal Code, as a co-principal of Vincent by indispensable cooperation for making the false order that enabled Vincent to evade service of his sentence. As to Edwin, the jail guard who escorted the prisoners in getting out of jail, committed the crimes of number one, infidelity in the custody of prisoners, especially in conniving with or consenting to evasion of leaving unguarded the prisoners escorted by him and providing them an opportunity to escape, which is found in Article 223 of the Revised Penal Code. And the second is direct bribery for receiving the amount of 50,000 pesos as consideration for leaving the prisoners unguarded and allowing them the opportunity to escape, which is found in Article 210 of Revised Penal Code. And to the jail warden did not commit nor incur a crime, there being no showing that he was aware of what his subordinates had done, nor of any negligence on his part that would amount to infidelity in the custody of prisoners. Okay, next topic is the book 1, which is the fundamental principles. Okay, the limitations in enacting the penal laws. Number 1, the law must be general in its application. Number 2, it must not partake the nature of an ex post facto law. Number 3, it must not partake the nature of a bill of attainder. Number 4, it must not impose cruel, excessive fines or degrading or inhuman punishment. Number 5, it must observe substantive and procedural due process. This was asked in 2010 bar. Doctrine of Pro Rio in relation to Article 48 of the Revised Penal Code. Following the doctrine of Pro Rio, crimes under Article 48 of the Revised Penal Code are complexed and punished with a single penalty that prescribed for the most serious crime and to be imposed in its maximum period. The rationale being that the accused who commits two crimes with a single criminal impulse demonstrates lesser perversity than when the crimes are committed by different acts and several criminal resolutions. This is found in People versus Comadre in GR number 153559 on June 8, 2004. However, Article 48 shall be applied only when it would bring about the imposition of a penalty lesser than the penalties imposable for all the component crimes if prosecuted separately. Another question here. What is protective or utilitarian theory under the criminal law? The protective or utilitarian theory under the criminal law, it provides that the basis of penalty and purpose of punishment is to protect the society from actual and potential wrongdoers. It behoves upon courts that in imposing penalties, it is only upon actual and potential wrongdoers, even in violation of special penal laws, wherein intent is immaterial. Judges should only impose penalties to actual and potential wrongdoers. This site is found in Magno versus Court of Appeals, which is found in 210 SCRA 471 or GR number 96132 of June 26, 1992. Another, may an act be malum in se and be at the same time malum prohibitum? Yes. An act may be malum in se and malum prohibitum at the same time. In People versus Sonico et al., it was held that the omission or failure of election prosecutors, failure of election inspectors and poll clerks to include a voter's name in the registry list of voters is wrong per se, because it disenfranchises a voter of his right to vote. In this regard, it is considered as malum in se, since it is punished under a special law, which is found in Section 101 and 103 of the Revised Election Code. It is considered also a malum prohibitum. Another question, is the crime of technical malversation punished under the Revised Penal Code mala in se? The answer, the crime of technical malversation punished under Article 220 of the Revised Penal Code was held to be crime that is malum prohibitum. The law punishes the act of diverting public property earmarked by law or ordinance for a particular public purpose for another public purpose. The prohibited act is not inherently immoral, but becomes a criminal offense because positive law forbids its commission on considerations of public policy, order, and convenience. Therefore, good faith and lack of criminal intent are not valid defenses. It is found in Isidoro versus People, GR number 192330, November 14, 2012. Another question, is the crime of plunder mala prohibita or mala in se? The answer, it is a mala in se. Although punishable under the special law because it is inherently evil, being included among the heinous crime punishable with reclusion perpetua to death, and its constitutive crime are mala in se, such as malversation of public funds, bribery, and monopolies and combinations. This is found in Joseph Estrada versus Sandigan Bayan, GR number 148560, November 2, 2001. Another question here. Abe, married to Liza, contracted another marriage with Coney in Singapore. Thereafter, Abe and Coney returned to the Philippines and lived as husband and wife in the hometown of Abe in Calamba, Laguna. What crime, if any, can Abe be prosecuted? This was asked in 1994 bar exam. The answer, Abe, together with Coney, may be prosecuted for concubinage under Article 334 of the Revised Penal Code for having cohabited as husband and wife. Note, Abe may not be prosecuted for bigamy, since the bigamous marriage was contracted or solemnized in Singapore. Hence, such violation is not one of those where the Revised Penal Code under Article 2 thereof may be applied extraterritorially. The general rule on territoriality of criminal law governs the situation. Another question here. The Philippine consul asked his secretary to work overtime because they were finishing some important repatriation papers in the embassy. The said consul asked his secretary to give him a cup of coffee. The consul asked the secretary to join him. When the said secretary went to the restroom, the said consul placed something in the coffee of the secretary. The secretary felt dizzy and lost consciousness. The consul then raped her inside his own office. The said secretary wants to file a case against the consul. Where shall the secretary file the case? Is the said consul liable under the Philippine laws? Here's the answer. The secretary shall file the case in the Philippines, although the crime committed, which is rape, is not in any way connected with the performance of his official function, since it was committed outside the Philippine embassy. Philippine laws will apply. The Philippine embassy is considered as an extension of the Philippine sovereignty. So even if the crime committed
is not in any way connected with the performance of their functions, but the crime is committed inside the Philippine embassy, then Philippine laws will still be applied. Another question here. Five informations charging Francisco Inocencio with acts of theft allegedly committed in conspiracy with Maria Milagros Clemente were filed before the RTC. In the said informations, it was alleged that Clemente, a bank officer, fraudulently transferred 1,000,000 pesos to Inocencio's bank account, and the latter later withdrew the whole amount. The information alleged conspiracy, but only one person is charged. Is the information valid? Here's the answer. Yes, it is valid, but the court cannot pass verdict on the co-conspirators who were not charged in the information. The non-inclusion of the co-conspirator does not invalidate the information, especially since conspiracy is not charged as a crime, but is merely alleged as a mode of committing the crime. In this case, conspiracy is alleged only as a mode of committing the crime, and ideally, Clemente and the petitioner should have been indicted together. However, the non-inclusion of Clemente does not invalidate the information filed, especially since conspiracy is not charged as a crime, but is merely alleged to show how criminal liability was incurred. And for another topic here, the next topic is felonies. Okay, here's a question. When are light felonies punishable? Okay, light felonies are punishable only when consummated, with the exception of those committed against person or property. And here's some question. Luis Cruz was deeply hurt when his offer of love was rejected by his girlfriend, Marivela, one afternoon when he visited her. When he left her house, he walked as if he was sleepwalking, so much so that a teenager snatcher was able to grab his cell phone and flee without being chased by Luis. He went to the LRT station. He boarded one of the coaches bound for Baclaran. While seated, he happened to read a newspaper left on the seat and noticed that the headlines were about the sinking of the super ferry while on its way to Cebu. He went over the list of missing passengers who were presumed dead and came across the name of his grandfather who had raised him from childhood after he was orphaned. He was shocked and his mind went blank for a few minutes, after which he ran amok and, using his balisong, started stabbing at the passengers, who then scampered away, with three of them jumping out of the train and landing on the road below. All the three passengers died later of their injuries at the hospital. Is Luis liable for the death of the three passengers who jumped out of the moving train? Okay, state your reason. Here's the answer. Yes, Luis is liable for their deaths because he was committing a felony when he started stabbing at the passengers, and such wrongful act was the proximate cause of said passengers jumping out of the train. Hence their deaths. Under Article 4 of the Revised Penal Code, any person committing a felony shall incur criminal liability, although the wrongful act done be different from which he intended. In this case, the death of three passengers was the direct, natural, and logical consequence of Luis's felonious act, which created an immediate sense of danger in the minds of said passengers who tried to avoid or escape from it by jumping out of the train. This case is in People versus ARPA, 27 SCRA 1037. And also in US versus Valdez in 41 Philippine 497. Okay, here's another question. Mary Jane was among the freshman law students who wished to join the Ang Tombi fraternity. She, along with her fellow neophytes, were informed that they were required to undergo the initiation rites, and that such rites would include physical beatings. On the first day of the initiation rites, they were subjected to traditional forms of Ang Tombi initiation rites. On the second day, they were likewise subjected to similar rites and beatings. The rites for the second day initially ended. However, due to insistence of Edward and Caesar, alumni fraternity members, they were reopened once again that night. The neophytes were subjected to additional beatings. Later that night, Mary Jane started shivering and mumbling incoherently. She was rushed to the hospital wherein she was found dead on arrival. May Edward Caesar and his co-accused be found liable for the intentional felony in this case? Okay, here's the answer. No, Edward Caesar and his co-accused may not be found liable for an intentional felony as an act that is malum in se. The existence of malicious intent is fundamental since injury arises from the mental state of the wrongdoer. If there is no criminal intent, the accused cannot be found guilty of an intentional felony. The mere infliction of physical injuries, absent malicious intent, does not make a person automatically liable for an intentional felony. Malicious intent must be judged by the action, conduct, and external acts of the accused. The specific animus injuriandi or intent to injure was not present in this case, even as the specific acts of punching, kicking, and paddling were done voluntarily, freely, and with intelligence, thereby satisfying the elements of freedom and intelligence. The fundamental element of crime intent was not proven beyond reasonable doubt. All that was proven was that the acts were done pursuant to the tradition. So this is found in Villarreal versus People, GR number 151258, February 1, 2012. Here's another topic, stages of execution. Antonio and his wife employed AAA and BBB to help them in their plastic and glassware business during a town fiesta in La Union. After fixing the wares in order for display, they went to bed inside the tents. Less than an hour passed, AAA was awakened with Antonio on the top of her, mashing her breast and touching her private parts. AAA fought back and was able to free herself from Antonio. She went out to seek for help. Is Antonio guilty for the crime of attempted rape? The answer, no. Antonio is not guilty of attempted rape. The act of Antonio embracing AAA and touching her private parts and breast did not directly manifest his intent to lie with AAA. The lack of evidence showing his erectile penis being in the position to penetrate her when he was on top of her deterred any inference about his intention to lie with AAA. At most, his acts inflicted lewdness and lust for her. So that was found in Cruz in Cruz versus People, GR number 166441, October 8, 2004. I repeat, no, Antonio. No, Antonio is not guilty of attempted rape. Okay. Next question here is, Jefferson was simply fetching water when Kevin suddenly hit him on the nape of his neck. Jefferson complained about this to his landlady, Kevin's sister, but the latter simply told him to forgive his brother. 2 hours later, when he resumed fetching water, Kevin suddenly stabbed Jefferson on the left part of his face and chest. He was found bleeding by his son-in-law and was rushed to the hospital. According to the medical report submitted, the chest wound he sustained was fatal and could have caused Jefferson's death were it were not for timely medication intervention. So what crime is committed by Kevin? The answer, Kevin is liable for frustrated homicide. The essential element in frustrated or attempted homicide is the intent of the offender to kill the victim immediately, before, or simultaneously with the inflictions of injuries. Intent to kill, being a state of mind, is discerned by the courts only through external manifestations. In this case, Kevin wielded and used a knife in assaulting Jefferson. There is also no doubt that the wound on Jefferson's chest would have been sufficient to result to his death if it were not for the timely medical intervention. This case is in De Guzman Jr. versus People, GR number 178512 on November 26, 2014. Another topic here is the conspiracy and proposal. What is the doctrine of implied conspiracy? The doctrine of implied conspiracy holds that two or more persons participating in the commission of a crime are collectively responsible and liable as co-conspirators, even in the absence of any agreement to that effect. When they act in concert, demonstrating unity of criminal intent and a common purpose or objective, the existence of a conspiracy shall be inferred or deduced from their criminal participation in pursuing a crime, and thus the act of one shall be deemed as the act of all. And here's another case. One night, after escorting his guests outside the house, Allen noticed that garbage was placed in front of his house. Allen, addressing nobody in particular, complained of the garbage. Jeff and Kevin, thinking that Allen was addressing his complaint to them, were angered and started throwing stones at him. Allen rushed inside his house to wash his bloody face and to arm himself with a piece of wood. However, before he was able to retaliate, he was hit by a shovel by Jorimon. Joseph and Jose held Allen, rendering him helpless, while Jeff and Kevin stabbed him in the abdomen with a knife. Allen lost consciousness and was confined in the hospital for 9 days. Assuming that they were convicted for frustrated murder, what is the extent of criminal liability of Jeff, Kevin, Jorimon, Jose, and Joseph? The answers: they are liable as co-conspirators. Conspiracy presupposes unity of purpose and unity of action towards the realization of an unlawful objective among the accused. Its existence can be inferred from the individual acts of the accused, which if taken as a whole, are in fact related and indicative of a concurrence of sentiment. The chain of events leading to the commission of the crime adequately established a conspiracy among them. Jeff and Kevin delivered the initial attack on Ellen and stoning him. Afterwards, Jerimon struck him with a shovel, and finally Joseph and Jose held him so that the others can stab Allen. And this is found in Ibanez et al. Versus People in GR number 190798 of January 27, 2016. Here's another case. A Starbucks van driven by Mayor Mitra and an ambulance driven by Morelia were caught by the police in the checkpoint with a sack of shabu inside the two vehicles. The Starbucks van, which was ahead of the ambulance, was able to pass the checkpoint set up by the police officers. However, the ambulance driven by Morelia was stopped by the police officers, and further examination revealed the sacks inside the van contained shabu. Morelia told the police officers that he was with Mayor Mitra in an attempt to persuade them to let him pass. This discovery prompted the operatives to chase the Starbucks van of Mayor Mitra. Sacks containing shabu was also discovered. Is there conspiracy established between Morelia and Mayor Mitra? The answer? Yes, there is a conspiracy. In conspiracy, it need not be shown that the parties continually came together and agreed in express terms to enter into and pursue a common design. The assent of the mind may be, and from the secrecy of the crime, usually inferred from proof of facts and circumstances, which, taken together, indicate that they are parts of some complete whole. In this case, the totality of the factual circumstances leads to a conclusion that Morella conspired with Mayor Mitra in common desire to transport the dangerous drugs. This case is found in People versus Morelia, GR number 189833, February 5, 2014. Here's another question. How is conspiracy proven? Jurisprudence requires that conspiracy must be proven as a crime itself. Conspiracy exists when two or more persons came to an agreement concerning the commission of a crime and decide to commit it. Proof of the agreement need not rest on direct evidence, as the same may be inferred from the conduct of the parties, indicating a common understanding among them with respect to the commission of the offense. It is not necessary to show that two or more persons meet together and entered into an explicit agreement, setting out the details of an unlawful scheme or the details by which an illegal objective is to be carried out. The rule is that conviction is proper upon proof that the accused acted in desert, each of them doing his part to fulfill the common design to kill the victim. This explanation is found in People versus Villalba, GR number 207629 of October 22, 2014. Here's another question of the 2004 bar exam. XA, YB, and ZC planned to rob Miss OD. They entered her house by breaking one of the windows in her house. After taking her personal properties, and as they were about to leave, XA decided on impulse to rape OD. As XA was molesting her, YB and ZZ stood outside the door of her bedroom and did nothing to prevent XA from raping OD. What crime or crimes did XA, YB, and ZZ commit, and what is the criminal liability of each? The crime committed by XA, YB, and CZ is the composite crime of robbery with rape, a single indivisible offense under Article 294, Paragraph 1 of Revised Penal Code. Although the conspiracy among the offenders was only to commit robbery and only XA raped OD, the other robbers, YB and ZC, were present and aware of the rape being committed by their co-conspirator. Having done nothing to stop XA from committing the rape, YB and ZZ thereby incurred in the commission of the rape by their co-conspirator XA. The criminal liability of XA, YZ, and ZZ shall be the same. They are principals in the special complex crime of robbery with rape, which is a single indivisible offense where the rape accompanying robbery is just a component. Another topic here is the multiple offenders. Okay, there are 4 kinds of multiple offenders. They are the recidivism, the reiteration, the habitual delinquency, and last is the quasi-recidivism. Okay, number 1, the recidivism. The recidivism is the offender at the time of his trial for one crime shall have been previously convicted by a final judgment of another crime embraced in the same title of the RPC or the Revised Penal Code. Number 2, this is about the reiteration. The reiteration is the offender has been previously punished for an offense which the law attaches an equal or greater penalty, or for 2 or more crimes to which it attaches a lighter penalty. Number 3, habitual delinquency. The habitual delinquency is the offender within the period of 10 years from the date of his release or his last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa, or falsification, is found guilty of any of the said crimes a third time or oftener. Note, it is important that the previous convictions refer to the felonies enumerated in Article 62 of the Revised Penal Code. If, for example, the accused was convicted for illegal sale of dangerous drugs, he cannot be considered a habitual delinquent. Number 4, quasi-recidivism. Quasi-recidivism, any person who shall commit a felony after having been convicted by final judgment before beginning to serve such sentence or while serving such sentence shall be punished by the maximum period prescribed by law for the new felony. Okay, recidivism and reiteration are generic aggravating circumstances which can be offset by mitigating circumstances. Habitual delinquency and quasi-recidivism, on the other hand, are special aggravating circumstances which cannot be offset. And here's another case. Defendants, appellants, inmates of Davao Penal Colony, and while serving sentence therein, were found guilty of crime of murder for killing one Regino Gazang. In imposing the penalty, the trial court sentenced them to suffer the penalty of death. Appreciating against all the defendants the special aggravating circumstance of quasi-recidivism, and to two of them the aggravating circumstance of reiteration. Is the trial court correct? Here's the answer. No, it was error for the trial judge to consider against the accused the aggravating circumstance of having been previously punished for two or more crimes to which the law attaches lighter penalties. Because the said aggravating circumstance of reiteration requires that the offender against whom it is considered shall have served out his sentence for the prior offenses. Hence, the accused were still serving their respective sentences at the time of the commission of the murder. However, the special circumstance of quasi-recidivism was correctly considered against all the accused who were at the time of the commission of the offense were undoubtedly serving their respective sentence. This is found in People versus Lison et al., GR number L 25177, October 31, 1969. And so that's the end of the part 1 of the UST Criminal Law Pre-Week Notes of 2016. And I'll be back for the part 2. Thank you so much for listening. I do hope I contributed something to help your criminal law review for the Philippine Bar exam. I am doing this reading or audio to help also myself as I am struggling with my focus in reviewing the bar exam. I really find it hard to study, especially reading these notes, so I decided to make this video so that even if I am doing something or I am in public places, I still be reviewing the bar in my earphones. If you want also a copy of my reading audios, please send me a message, or if you want me to read some other bar reviewers in my email ad, sender5681 at gmail.com, or to my Facebook page, sender5681. It would be a pleasure to help others while I am reviewing for the bar exam, and I am so happy to share these things to my fellow bar candidates. Thank you so much, and God bless.